Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Now, we have a question here from Just Racing, which is a great username, who asks us, I filed a discrimination complaint with the New York State Division of Human Rights. Charging documents came back with both state charge and a federal charge. A document included with the packet from the EEOC says your complaint will be investigated by the New York State Division of Human Rights. What does this mean in regards to the EEOC charge? Especially if the New York State Division of Human Rights finds proof, settles, or goes in front of an ALJ, administrative law judge. Is its own case continuing then with the EEOC? Your channel has helped me immensely during my journey. Thanks. Just! Exclamation point, exclamation point. Pew, pew! Right? That's what I assume when I see the double exclamation point. Pew, pew! Okay, so, listen. Just Racing, great question, savvy question. Here's the deal. You have been automatically cross-filed. When you filed the State Division of Human Rights, your case was automatically cross-filed with the EEOC. You can opt out of this. You did not, so you're filed on the federal level and the state level. Now, that's pretty meaningful for a couple of reasons. One, there's some advantages to the state laws in New York and some advantages to the federal laws that span our country. And in different situations, you might want to use one or the other. Two, you have preserved your federal rights. Your federal statute of limitations is shorter than your New York State statute of limitations. Depending on where you are, it's either 180 days or 300 days to get filed with the to get filed with the EEOC from your last act of discrimination. But ideally, you don't want just your last act. You want more events included. Now, that's positive because you might, at some point, pull out of the State Division of Human Rights and say, I want to go file this in federal court. And you would get your right to sue letter from the EEOC, the Equal Employment Opportunity Commission, on the federal level, and that would allow you to file your federal claims in federal court, assuming you're dealing with workplace discrimination or workplace sexual harassment, and then you could also file your New York State and New York City claims in that federal action as well. So that's another advantage. Now, your question primarily deals with what does this mean if my case is disposed of in some way, right? So you list here, if the State Division finds proof, which I think you mean probable cause, right? So if they find probable cause, they're going to grant you a 2-day hearing. Now you can accept that hearing, or you can pull out of the State Division and go to either state court or federal court. So if you have probable cause in the State Division, excuse me, it's like when I make a video, I just start coughing, but I'm not coughing normally. I'm on new medication for the coughing. So, okay, you get probable cause in the State Division, and sometimes people don't want to have their case go forward in the State Division for whatever reason. They want a jury. They want more discovery than the State Division process offers. They don't like the ALJs, the administrative law judges being offered. You know, there's a lot of things. They want a longer process than the 2-day hearing offered by the State Division. So you might say, hey, I want to take my case out of the State Division. I want to go to federal court. That EEOC filing makes that possible. If you go to trial in the State Division, it will extinguish all of your claims. Whatever the decision is, for you, against you, anything. Likely, very likely, listen, nothing's impossible. I don't know all your claims. I don't know your situation. I can't give you definitive answers here. But generally speaking, that process will likely extinguish all of your claims, federal, state, city. Poof, they're done. They've been adjudicated. Now, on the other hand, well, we'll deal with settlement. You also asked about settlement. So that's if probable cause is found. If your case settles at the State Division, that's going to include a general release of all claims. Federal claims, state claims, city claims. The opposing counsel, the defense attorney on your case would have to be insanely incompetent. Like incapable of using boilerplate settlement agreements, levels of incompetent, to not have a general release of all claims in that settlement. Could it happen? Sure. Has it happened? I'm sure it has. It's probably not going to happen to you. statistically speaking, we're talking like 0.1% of these cases might not be settled properly. If they're settled, right, somebody just might not understand how to properly paper the settlement or handle the settlement. And listen, something could survive on in that scenario, but it's incredibly rare. I've seen it. Sometimes employers will go hire their general practitioner or use their in-house person who's not very versed in employment law, or, even just an attorney who lies about being an employment attorney, which is more common than you think. And so the employer, the defendant, will have inadequate counsel, and that's on them. That's their problem and their fault. Nobody feels bad for them. And if they settle in an ineffective fashion, listen, we'll certainly be looking to bring that claim forward that survives if we can, right? So could that happen? Sure. Is it going to happen to you? It's probably not, realistically speaking, right? So if your case settles, it's very likely that all your claims are disposed of. There's also the option you could have a carve-out, right? Sometimes people will settle a case but have a carve-out for some other claim that's not being adjudicated in the settlement. That does happen from time to time. It's unlikely to happen in this scenario, but it could. It could, right? Lastly, in the state division, you could get a result called a no probable cause finding. The finding of no probable cause means you're not going to have your 2-day hearing in the state division. And it means that your New York state law claims are extinguished. They have been adjudicated by a state representative, and they are likely not going to be able to go forward. But wait, you've got something up your sleeve. You've still got federal claims. And the federal government, in all of its beautiful, glorious arrogance, doesn't give one flying hoo-ha what the state of New York thinks about a claim. So the EEOC, you can ask them to do their own investigation. Likely they will not, because that takes work. And these are government employees, and they don't care about you. However, they will do something for you that will get rid of you from their perspective. They will say, instead of doing an independent investigation for you, we'll give you your right to sue letter. And you can go on to federal court, and you can bring some of your claims that survive, not the ones extinguished by the state division, but the other claims that survive, including the federal claims, most importantly the federal claims, you can bring those to federal court. You're going to get essentially what amounts to a second bite at the apple, right? One of the core concepts of our legal system is, hey, you get one bite at the apple. You get one chance to prove your case. Generally speaking, it's important for the efficiency of the courts. It's important for defendants who don't want to have to defend claims repeatedly. Like there's a lot of reasons for this concept to be kind of eminent in our legal system, and they're all tied to efficiency. You get one chance. But not today. Not today. You get, if you did things correctly, a chance to get your right to sue letter from the EEOC, even though the state division has already found against you in that no probable cause finding. And you get to take that right to sue letter, go to federal court, and have your day in court. That is as wild as it seems. And it's incredible. And it has been the means by which so many cases have been rescued from little shitheel attorneys who did a bad job in the state division. But they just happened to, the cross-filing took place, and the clients go and they hire a good attorney now, and the good attorney says, well, you still got a right to sue letter. Let's go to the big show. Let's make federal court happen, right? You wanted to feel like you're on TV? That's the process. It makes you feel like you're on TV in a courtroom, right? That's the big show. That's the game. That's where complex litigation meets everything. Like meets the pedal meets the pedal meets the metal. The rubber meets the road. Like complex litigation happens, and you're gonna have jury selection. You're gonna all the things you see on court TV or law, whatever, crime and law network that I used to appear on, Law and Crime. I don't even know the name of the network. The court cases they show, listen, some of those are in state courts, but like a lot of those, there's a lot of federal courts, right? The biggest criminal, mafia, cartel leaders, all the biggest stuff. It's happened in federal court. You're going to be in the same courtrooms. Sometimes that sucks because you got to fight reporters to get where you're going. but it's also like you're on the big stage. In terms of the law, this is the biggest attainable stage for most people in this country, right? People instantly are like, but you go before the Supreme Court. Good luck. Good luck getting there. You got, how many million you got? How many backers you got? You think they're going to choose your case? Is your case novel enough? Does it fit someone's political agenda? Unlikely. Unlikely to happen. So this is the highest attainable court in the land for most human beings. And you snuck in on a second bite of the apple. Congratulations. You've got some options. Now, listen, I hope your state division case goes great. I hope you don't need that option. Very sincerely, I hope you get paid big time. You get vindicated. All the wrongs are righted. You're made whole. I hope that for you. But if some hiccup occurs along the way, if some state division investigator or director acts the fool, I like that you have options. And I get frustrated when firms don't preserve those options for their clients. Because I don't, you didn't want to cross-file 15 minutes to protect your client who's giving you how many percent of what they went through? 15 minutes. You couldn't be bothered to just secure that second bite of the apple? I don't know. Maybe you can explain that to me. Why couldn't you be bothered? Do you hate yourself or your client? Right? I mean, come on. What are we doing here? Right? Like it's absurd, right? So, listen. Just Racing. Well done. Sounds like the filing went well. This is what it means. And I wish you success. If this was helpful, like, subscribe, comment down below, share the channel so it may grow. Take care, everybody.